and I don't know how to straighten that out exactly.
Court calls the matter of Loker versus Loker, case number 2015-6231 DM. All parties and attorneys can please state your name and appearance for the record, starting with the plaintiff's attorney, Ms. Sharma.
May it please the court, Namita Sharma on behalf of plaintiff Devin Loker, who is appearing with me via Zoom.
Good afternoon, Your Honor. Alicia Storm appearing on behalf of the defendant, Chelsea Loker, who is also here via Zoom.
And the parties you want, Devin, go ahead. You can, I guess, if the court wants that.
Good afternoon, Your Honor. Devin Loker, plaintiff.
Chelsea, if you could unmute and introduce yourself too. You're still muted.
Oh,
There you go.
good afternoon, Your Honor. Chelsea Loker, defendant.
One other party.
Good afternoon, Your Honor. This is Joanna Sisk, third party.
Good afternoon, everyone. Today's date and time is set for a hearing. Due to the pandemic, Supreme Court and Chief Judge have made decisions to handle these matters by remote technology. Contents of this video may be the official record of a proceeding of the state of Michigan's 9th Judicial Circuit. Unauthorized duplication, distribution, alteration of said content is strictly prohibited. On May 3rd, there was an ex parte motion to suspend parenting time, filed by Ms. Sharma on behalf of her client. Briefly, it looks like I'm betting we're going to set this matter for hearing, but where are we at, Ms. Sharma?
Thank you, Your Honor. I can tell the court that this matter was one that was resolved by placing an agreement on the record on December 3rd, 2020. Full day hearing was set with referee Percunier on pending motions that had been, I think, filed before I was involved in the case, but in 2019 by the defendant, Ms. Loker. We reached a comprehensive settlement and only, I think, recently settled on the order. We exchanged many orders back and forth, but so the order may look very recent, but it was an actual December resolution on all issues that were pending at that time. We're also set for further hearings down the road with referee Percunier, sort of for a review slash update on the progress regarding mom's what we call a bridging schedule for parenting time. And I believe I stole that word from Attorney Storm. That was her initial phrase. So regardless of the procedural history, I think that the important thing for the court to know is that since that December 3rd date, and that's why I gave a little bit of background, was to let the court know that there were changes that came to light after the settlement was placed on the record on December 3rd, 2020. In fact, they were only recent occurrences where a third party has forwarded very disturbing social media information regarding the defendant, and all of that, but raises the alarm for my client. And the reason it raises the alarm for my client is because there's been a history, and why the bridging schedule even is needed in the first place is that there was a time period when, to put it quite bluntly, mom wasn't able to parent. That's why we have a third party involved still. Third party was at some point involved because the third party is the intervener and the mother of defendant. And she was the sort of substitute parent when mom was unavailable for a substantial period of time. Some of that involves substance abuse or substance use and things that relate to mom's mental health. We believe it's damaging to the children if they're around mom under those. Okay. Sorry, Your Honor, shall I wait a moment?
No. We were limited time, but I'm trying to figure out, there's a motion for ex parte filed the same day the consent order was done.
That's right. And that just was, I think it's a function partially of COVID, but the order was resolved. It took some hearings. I think we had gone back and forth. My order was finally or my, anyway, we resolved it regarding the language on that day. And we had to have an order in place. Otherwise, the only order that would have been relevant for the court was the judgment of divorce, which set forth mom's parenting time. So in other words, the parties divorced. Dad was granted sole legal and sole physical custody. Third party intervener filed a motion for grandparenting time. They reached an agreement. Subsequently, mom filed, well, the next day, I believe, mom filed a motion to gain parenting time herself. That was not resolved until December 3rd of 2020. I believe that's the procedural background.
Okay. So what do you want today? You want her parenting time suspended?
I want something done, Your Honor, and if an evidentiary hearing is necessary, we believe that there has been some backsliding or whatever it is that I can use as the phrase to describe mom's behavior, which we didn't know about in December. And I think, honestly, my client's position is, had he known about some of the stuff that was going on, that it relates to mom drinking again and mom perhaps putting the children in a unsafe environment, would have lent him to make a different decision regarding the settlement. And certainly once this was very recently revealed, I guess, right around the time that I filed my motion for ex parte relief, I told him we couldn't do anything until we got an order in place so the court knows what mom's current parenting time is that the judge has got to make a decision on. So once we got that order resolved, we filed that motion. And I want the court to know that my client's worried about the children being in mom's care without any kind of supervision, without any kind of oversight because of her behavior that he has been seeing.
Ms. Storm, your response?
Yes, Your Honor, and I'll try and keep it brief. Our position is that these videos are old and they predate the agreement. These videos are taken out of context and not accurately represented by the plaintiff. His motion was based on speculation and a personal grudge against my client. That the last hearing that we were in court, Ms. Sharma indicated that a motion was pending, but she gave no indication that it was this. We thought it was going to be regarding the third party. So this gives support to the fact that they knew this was going on. This is not new information to them. My client is not taking any drugs, illegal or otherwise. She takes her prescriptions as directed. She does not drive recklessly. She has no tickets or DUIs or anything. I don't believe that anything alleged actually rises to the Vod Barca threshold, and that this is just more needless litigation by the plaintiff, who is a lawyer himself, and it's designed to frustrate my client's parenting time and potentially litigate her out of continuing to try for her parental rights and parenting time. We believe that this is more about plaintiff's desire for control of the kids, the case, and my client, just trying to halt or impede her parenting time. He's jumped to conclusions and used it to file a motion instead of actually contacting my client to discuss or address. We'd request that this motion be dismissed or set up for an evidentiary hearing that we already have scheduled in December of this year. My client already receives very limited parenting time. She's exercised parenting time since the December agreement, and no issues have happened and no problems have happened with the children. There's been no negative impact on the children. There's no reason to modify her already limited parenting time pending our hearing in December.
Okay. This really doesn't concern your parenting time per se, so I don't know if you have any position on any of this. It looks like it's going to be set for an evidentiary hearing. But Ms. Sis, anything you want the court to be made aware of with regards to these motions?
Absolutely. Chelsea, definitely. We are with her when she has the kids very often. I can tell you she does not use any illegal substances. I can tell you that.
Hold on, ma'am.
Yes,
That's
ma'am.
stuff for the that's stuff for the hearing. Anything
Okay.
procedurally at this time?
Yes, actually, regards the judgment that I did receive for grandparenting time. Specifically in our paperwork, it states that I receive 1 full week in the summertime with the kids, and our dates are to be settled upon by May 31st. I've reached out to Mr. Loker 4 times with regard to these dates, and he has not responded back for them.
Okay. Well,
So
did you send those also to his attorney?
I did not. I was told via paperwork that I'm to deal with Mr. Loker and he's to deal with me. I mean, our case was settled quite some time ago.
Well, follow the order, but if you want, as a courtesy, you could send it to Ms. Sharma right now.
Okay,
Because this court does not look kindly on people trying, if it's the case, not answering emails. So you can send it to Ms. Sharma as well, and it should be settled by May 31st.
okay,
But that's not before me today, so I can't do anything about that.
all right.
Okay,
So what,
well,
I wasn't clear
I
on
have
what.
go ahead, ma'am.
I wasn't clear on why I was included in today.
I'm not either, but you're a party with some grandparenting time, so I guess they didn't want to leave you out.
Okay,
Okay, so we'll set this matter for an evidentiary hearing in front of a referee. I have two very different versions of events. Knowing when these videos occurred may be the most important thing. If these are old, then no, we're not going to relitigate it when there was an agreement. But if they're new, then that could be something entirely different. And it looks like through the phrases "Merry Christmas" and stuff, they may be old, but I'll let the hearing official decide that. So we'll get it set for a half day. Not going to make it. I'm going to ask all prior orders remain in effect. I'm not going to alter anything at this time. There's not enough there to say that these children are in danger since when the consent order was agreed upon. Anything else before we get you folks a date with, we'll have to mail out a date because we got to check to see which referee will be handling it. Anything else before we adjourn?
Your Honor, Ms. Storm and I do know that, we have these upcoming dates with Ms. Referee Pecunier, who had a lot of involvement in our reaching our settlement, and she has some prior knowledge of it. So I know that for purposes of efficiency, Ms. Storm and I had agreed that Ms. Pecunier, Referee Pecunier, had these upcoming hearings anyway in December and November of this year. So it may be logical that that would be the referee who'd handle it regarding.
If I put it with those dates, we're going to be waiting 6-7 months before we get before Referee Pecunier. That's what you folks want. I'll look into it, but
No, not the dates that we already have on record. I'm sorry.
I think what Namita is saying, that if, as you're looking at dates, if they're not that we can necessarily request a referee, but if we were able to request a referee, we'd probably request Referee Pecunier, as she's the most familiar with this case, having heard it several times and several issues that she's helped us resolve.
well,
and that was just because you said a referee. Sorry.
okay. Yep, and we will look into it, but that is not Referee Pecunier's position. It is for post-judgment custody matters. So it's not as easy as just assigning it to a referee. That's what happened when we created this position a few years ago. It's for custody matters. This is a parenting time matter. We will look into it and check schedules. Okay?
Thank you.
All right, we'll be adjourned. All prior orders remain in effect. Good luck.